Dosto que ele que na 1200 square foot गुड़ी नहीं
Hello, everyone. Am I audible to you? Oh, great. Should we start in a minute? Waiting for a few more to join. I'd like to request everyone to keep themselves on mute so that there's no background noise. Just one more minute before we start. So, hello everyone. Welcome to today's lecture on ND and NT versus Spaine, litigation before European Court for Human Rights on migration and EU borders. So, this one to bring to the European Court of Human Rights the Spanish long-standing practice of summary expulsion at its land border with Morocco. It was also a test case which questioned the dominant European narrative through which refugees have rights when other migrants do not. This challenge legally translated in a case which of collective expulsion without relying on prohibition of torture, inhuman and degrading treatment. This case was won before the chamber in 2017 and lost in front of the Grand Chamber in 2022. So the presentation will address the issues on illegal pushbacks and border violence. These pushbacks are a systemic consequence of EU's policy to limit access to asylum in EU countries. As a consequence, They've been carried out extensively at EU's external and internal borders. In carrying out these pushbacks, EU's police forces and border authorities often subject migrants and refugees to the most gruesome forms of repression. The presentation will also address the significance of this judgment from post-colonial and racial perspectives. So we have to present before us this case our special speaker, HANAA HAKIKI. Welcome, HANAA. HANAA is an Algerian French lawyer who is a senior legal advisor at European Center for Constitutional and Human Rights. HANAA's work addresses border rights since 2014 with a focus on litigating pushbacks, arbitrary expulsions at European Union's borders in front of international courts. HANAA is also a qualified solicitor, and in England, she had specialized in litigating cases of state violence, detention, and institutional racism. HANAA has been a Bertha Justice Fellow since 2015. I'm glad to have you to speak before us on this imperative topic, HANAA. Before much, one second, there's somebody. So without further delay, I'd like you to take up the topic and speak.
Yes, can you all hear me?
Yes, I can,
Okay,
I can.
Great. I'll just disappear for a second because I just realized I might run out of battery. Sorry, just a second.
Okay, sure.
Yeah, I'm here. Thank you so much for inviting me. I'm really honored and really excited. A bit surprised that you'd be interested in this topic because I think it's particularly depressing how European courts and the European Court of Human Rights in particular have been dealing with migrants and migrants' rights at the moment. I also have to say that I hope I don't offend any of you when I talk about being racialized and dehumanized in the European context. I mean, it's my reality because I live here. I don't know if it's yours, and I hope nobody gets offended. It's just the sad reality of being a descendant of formerly colonized people when one lives in Europe. I'll also say briefly that I come from the French Empire and discovered the British Empire when I went to study in England. So I think I'm a bit conscious of kind of both differences, but not fully. Yes, and I have a presentation, so I'll just share my screen with you. Hopefully it will work.
Oh.
And if there's any problems, just maybe say in the chat or let me know. Okay, so I think, can you see the presentation?
Yes.
Great. So, yes, so I've titled it Undocumented Male Migrants in front of the European Court of Human Rights, Legal Subjects, ? Because I think that was really, the case that we did in NDNNT sort of really asked that question. I mean, we didn't think it was a question. We thought that we would just do a case that would confirm that they were legal subjects, but in the end, that's not how it turned out to be. So just to quickly contextualize things here politically for this case, we're dealing with, you know, from the global North perspective and from the European perspective in particular, laws on migrations are just another way of managing former colonial subjects and a neo-colonial way of managing former colonial subjects. And I think it's really important to keep that in mind because otherwise it's difficult to understand the absurdity of the jurisprudence. And I think that in terms of the jurisprudence, there is a tension there between the resulting brutal, unjust, and completely oppressive border and migration regime that we have versus this civilizationist discourse on European values and human rights. And I think that in migration in particular, and this decision really shows it, when the highest instance in Europe, who specializes on the protection of human rights, takes the decision that they've taken, it really shows that it is just a discourse, it is just a facade, but the reality of the migration regime is one of brutality and unfairness. So I haven't used the term pushback because I thought it was maybe too European context. I'm just saying arbitrary expulsions because essentially that's what pushbacks are, and also because pushback is not really a legal term. It's a term to describe the practice, but basically the practice is one of arbitrary expulsions where there is no process, or there might be sometimes a process, but just really like a rubber stamping exercise of just issuing papers without really looking at the case or the people. And I just wanted to do a quick chronology to kind of understand how this, what was the situation when this case started and what it was when the judgment came out. Because the case was filed, so the case is about events that took place in summer 2014. It was filed in winter 2015, but the decision came in, well, last year, February 2020. So that's how long it takes to get decisions from the European Court of Human Rights, because they have about 100,000 cases a year of cases filed. And this was actually quite quick. So between 2014 and 2020, a lot changed in terms of border management. And so when we started, arbitrary expulsions were kind of an exception. So they happened in Greece and they happened in Spain. And in particular, they happened on the two Spanish enclaves. So these are two cities, two pockets, which are actually on the Moroccan coast, but are Spanish. But then 2015 happened, and what was called the refugee crisis, it wasn't a crisis. I mean, like, we should have been ready for it. But basically what happened is that many refugees and migrants, people on the move, a lot of Syrians were moving from Turkey up to, northern countries of Europe. And in 2015, the borders were open and transportation was kind of provided for, and it was relatively safe to get through. And then European countries had enough. They had a big meeting and they decided to close the borders in 2016. So they closed the borders, but people kept moving. So it just became less safe and much more costly and much less safe. And so when you do that, so you close the route, you stop safety and legality of movement. But the real question is, what do you do with the people who still cross the border? Because people will still cross the border. And what should be happening are individual examinations of each cases, whereby border officers or national authorities would decide, okay, do we provide protection to this person because they need, they have a right to protection because, for example, they're a refugee or they're an unaccompanied minor or whatever other reason, or do we need to deport them and maybe detain them until we deport them? But this is not what happens. What happens is that none of this happens. We just have arbitrary expulsions. Why I say that they're arbitrary is because there's a number of legal obligations that apply. And so states should be bound by national law, European law, and by European law, I mean both European Union law, which kind of defines a lot of the framework in countries that are members of the European Union when it comes to migration and asylum. So it has really directly enforceable laws on access to asylum, procedure for asylum, requirements for asylum, reception conditions, deportations, returns, everything is in EU law and is directly enforceable. And it's, regulated in detail. And then you also have the European Convention on Human Rights, which should be an extra layer of protection. And then, of course, all of the other international human rights treaty obligations, for example, the Convention on the Rights of the Child would be one, the Refugee Convention, of course. So all of these should be applicable, but none of it applies at none of the levels. And the practice of arbitrary expulsions raises various legal issues. One of them is violence, because often violence is involved. The second one is that of access to asylum. The third one is access to an individualized procedure. And I've put on the slide, you know, the different levels where each of those issues interplays and what kind of obligations or prohibitions also are involved. And the one that we focus on is the prohibition of collective expulsions in terms of access to an individualized procedure. And I've put the right to legal personality there because as we've worked further on the issue, I think it became to us quite clear that what was at stake was really the acknowledgement of people as legal subjects rather than legal objects that could just be, you know, called illegal migrants and thrown out. And the arbitrariness in arbitrary expulsions is not consequential. It really is inherent constitutive, and they're arbitrary because they need to be, because that's the only way. I mean, that's their function. Their function is to get rid of people on the move quickly. So to not give them access to the law, to place them really outside of the realm of the law and just get rid of them. And the violence is there to deter them from coming. And this is really clear from the reports that we have, that there's a preventive and punitive aspect to the pushback. So for example, all of the gear that people need to move will be burnt and destroyed. Their telephones will be confiscated and broken. The confiscation and breaking of the telephones plays two rules. One, it allows for any evidence to be destroyed. And the second rule is that it makes it much harder for people to organize and to actually locate where they are and to keep moving or even to just survive. And for example, people that are identified as being the ones that have the geographical knowledge of how to move around the borders are badly beaten up. So they're not taken to court or detained or prosecuted in most cases. They're simply very badly beaten up. People who raise the issue of their rights are badly beaten up. People who speak English and can communicate are used, but then also badly beaten up. Yeah. And so fast forward to when we actually get the decision, pushbacks are happening everywhere, as you can see. So that's not from me, that's from the European Union's Fundamental Rights Agency. And they're happening inside and outside. And they haven't put the ones at sea, but you also have pushbacks at sea. So from Spain to Morocco, or from Spain to Mauritania and Senegal, because they are like islands facing, Spanish islands facing the Western African coasts, or from Italy to Libya or to Tunisia, or from, so also at sea between Greece and Turkey. And I say they're systemic because they really are. So there is like the European policy when it comes to refugee and migration is one of containment. Since 2016, the idea is that most people are contained in what is called hotspots, which are basically detention centers, even though the court doesn't acknowledge that it is detention. And those hotspots are in Italy and Greece, because those are the two main countries where people arrive. And basically access to asylum is not working and the conditions are really horrific. So people get there, they get registered, they're supposed to start like a process, but the process takes long and the conditions of life are horrible. So they'll then just leave and eventually even get out of the European Union. So the countries where you see Serbia, North Macedonia are actually not part of the European Union, but you need to cross them to get on the other side. And people will, you know, basically leave a situation where they're registered to keep traveling because they're not getting anywhere in Greece or in Italy, and they'll have to travel unlawfully. And then what happens is that they get pushed back. And I think if the pushbacks didn't happen, I'm not quite sure what the EU would do. So like the European Union's institutions, including the Commission, always say, of course, you know, we can't accept people doing these violent pushbacks. But my question always is, okay, so let's say you do what you need to do to stop them. What have you put in place to actually deal with the people that are crossing the borders unlawfully? Like, do the courts have the capacity to look at their cases? Do you have reception centers that can accommodate them? Do you have lawyers that can represent them? And none of that is done. So it's clearly, there clearly is I would say, a secret condoning by the EU, if not financing of the pushbacks. So the case that we did was NT versus Spain, and the man there is NT, and this is his arbitrary expulsion. So he just came down the fence and immediately was brought through what you see, the barbed wire that you see is the border fence structure. So this is how Melilla looks. It's a city and it just has this like triple fence around it. And on the other side, it's Morocco. So the triple fence is like, so the blue side is Morocco and the purple side is Spain. And actually the border is where there is like next to the Spanish flag, this little dotted line, that's actually the border. So Spain actually starts even before this triple fence. So like theoretically, you could say that as soon as someone stands next to the fence, they're already in Spain and they're already in the jurisdiction of Spain. But what Spain used to say is that they in 2014, they kind of put in place this like concept of the chewing gum border. And they said that like, basically the border was wherever their border officers were standing beyond the triple fences, and that unless people managed to get past that by their own means, so for example, if they used the help of border guards material to get off the fence, this didn't count. So they needed to get past them by their own means in order for their entry to be acknowledged. And that anything before that, just like in that zone, until this like chewing gum, theoretical chewing gum fence, the law just didn't apply. So that was their, you know, the law didn't apply and you could just like send people back and you didn't have to go through like any deportation proceeding. In reality, that is how it looks like. So the picture is taken from the Spanish perspective and on the other side, it's Morocco. And this is actually the day on which ND and NT were expelled. And they were probably one of the people like that you can barely see on that triple fence. And the practice was pretty violent. This is how people were getting, you know, off the fence by just being, you know, beaten down it like fruits, basically, in front of cameras, like there was no, you know, sort of no taboo, and then being carried around in like what I can only describe as completely gratuitous, inhuman and degrading ways, in plain daylight in front of journalists again. So why did we decide to do this case? It was because there was a gap between the over-visibility of these arbitrary expulsions, these Spanish arbitrary expulsions that are called hot returns. So, you know, they were over-visible in the media, but there was nothing in courts. There were a few national proceedings, but these were always sort of public interest proceedings that didn't have any of the witnesses or the victims. And it was quite clear from the way that they were being handled that the courts were not going to stand up to this national practice that was completely condoned by the government. And in fact, when these proceedings ended, this is what happened. So, you know, the court just said, yes, okay, like there's a violation, but actually because it's state condoned, we're not going to do anything about it. And also because at the time in 2014, the European Court of Human Rights jurisprudence as to the prohibition of collective expulsions was quite clear, that unless and until there was an individual examination of the cases, there was a violation of the prohibition. And there had been like this really strong case in 2012 called Jama versus Italy, by which people who had been, so Italy had gone to the high seas and intercepted a boat of migrants and then just basically taken the migrants into their military boats, taken them to the Libyan coast and given them to Libyans. And the European Court of Human Rights in 2012 had said, you can't do that. And even though it's on the high seas, because you took control of these people, your jurisdiction still applies. And you violated the prohibition of collective expulsions because you didn't look, you know, you didn't examine those cases individually, you just brought people to Libya. So we thought, great, the jurisprudence is really clear and this practice is really visible. So we can get evidence, so we can go and challenge this practice. But we also didn't want necessarily to take people who had would have had refugee status because the discourse at the time was refugees have rights, economic migrants don't. And we thought, okay, so we focus on the prohibition of collective expulsions, and we will show that economic migrants also have rights, and namely they have the right to a procedure. You can't just, you can't just do what you want with them at the border. Yeah, so that's why we took that case. And also on that day, there had been a lot of journalists, so there were loads of images, but the images weren't that clear because the border guards, the Spanish border guards, had stopped journalists from approaching the fence. So what was our case? Our case was on jurisdiction, that there could be no chewing gum border, and that there was no lawless zone. So to go to the European Court of Human Rights, there's a requirement because the court is supposed to be sort of a last resort place, and also because issues are supposed to be dealt with nationally, there's a requirement to exhaust domestic remedies, but these domestic remedies need to be effective. And for an expulsion, an effective domestic remedy, so we argued that it was one that had to have automatic suspensive effect. So it's one that, like, as soon as you file it, it stops the process of the expulsion. Or we said at least you have to be able to actually access a remedy. But like in this position, they had access to nothing because nobody was allowed to go and see them. So when we did a field trip there, and we went and we arrived and collective expulsion was happening, and we weren't allowed to like approach at all. So you could say, I'm a lawyer, I'm a journalist, or I know this person, or like, look, this person's a minor. You weren't allowed to approach, so that effectively people at the fence had no way of getting to court, basically. On the evidence, we said that, so because Spain argued that like we couldn't prove that our two people had been on the fence on that day, and we said that they were estoppeled from making that argument because the reason why we didn't have any paperwork is because they didn't issue any paperwork, and the reason why we didn't have any better images is because the journalists were stopped from approaching. And then we argued a violation of the prohibition of torture, cruel, and inhuman treatment on the basis of the fact that, so our guys, ND and NT, they had been on the fence when they were expelled. It was about 3 or 4 in the afternoon, but they had arrived on the fence at about 4 o'clock in the morning. So they spent like 12 hours on this fence without any food, without any drink, and in the burning sun. But at night, whilst they were on the fence, they could see their friends being beaten up. So what the Spanish did that day is that they just opened the gates and told the Moroccan forces to come in and to get people out. And they like, those people at night were beaten up massively. And our applicants were saying, like, we were so scared, to fall off and to be beaten up like that. And we were scared that also, like, if they gave us to the Moroccan authorities, they'd just take us around the corner and beat us up too, to just kind of teach us a lesson so that we wouldn't come back to the fence. So we argued that because of that, expelling ND and NT on that day was exposing them to a risk of torture, cruel, or inhuman treatment, and that the expulsion had been, in violation of the prohibition of collective expulsions, but also that they didn't have they hadn't had access to an effective remedy, which is a right, though it's a right that you need to connect to another claim. So you can't just claim the right to an effective remedy. You kind of need to make a main claim, and then you add that on top of it. The court immediately ruled that the first ground was not admissible. We didn't get any reason why. They ruled that it was manifestly ill-founded. So in their view, like, from maybe we didn't present enough evidence. So the two that stayed were the prohibition of collective expulsion and the right to an effective remedy. And so Spain's argument was that they needed a caveat at the border zone, otherwise they just couldn't deal with migration, especially in Ceuta and Melilla, because like it was the only, they said it's the only land border of the EU with Africa. What do you want us to do? And then in terms of exhaustion of domestic remedies, they said, oh, ND and NT both, and it's true, ND and NT both at some point managed to have their entry in Spain acknowledged, like later, months later, and had deportation proceedings. And Spain said, well, they didn't do anything to successfully challenge those deportations. So it kind of shows that, you know, I mean, that's what they should have done, basically. They also said that there was, you know, no conclusive evidence of their presence amongst the group. So Spain said, yes, we did expel a big group of people on that day, but there is no proof that ND and NT were part of them. And then for the prohibition of collective expulsions, Spain said, well, it wasn't an expulsion because they were never considered having to have entered. So if you haven't entered the territory, you cannot be expelled with. The case kind of had a lot of third-party interveners. So this is where organizations can request permission from the courts to sort of send submissions to support a case or to give their view on the case. They're not supposed to actually give their view on the individual case, but rather on the situation or on the legal or factual situation. So we had UNHCR, we had the UN High Commissioner for Human Rights. I've put a few of the quotes that kind of stick with me. So the UN High Commissioner for Human Rights said, of particular concern to them are those conditions, so those pushbacks that negate the right to access a remedy from the outset. So, you know, like people arrive, you just push them back and they can't do anything. We had the Council of Europe's Commissioner for Human Rights. It's a pretty important person because the European Court of Human Rights itself is an institution of the Council of Europe. So having the Commissioner for Human Rights of the Council of Europe intervene is a big thing. And she also said that those kind of, you know, that acknowledging the legitimacy of those sort of arbitrary expulsions inevitably would erode fundamental rights protections and could constitute a dangerous encouragement for other European countries faced by an increasing arrival of migrants and asylum seekers. We also had the Spanish Commission of Assistance to Refugees who spoke about Spanish law in the situation, as well as Amnesty International and a bunch of others. And a few of those interveners also spoke, you know, had done visits or were present at the border and really spoke about the situation at the border and how, in particular, Black migrants had no other chance to get close to the border because there's racial profiling from the Moroccan side and from the Spanish side. So we had a first judgment by the chamber, which basically completely followed our arguments, and we won on everything. So they said, you know, jurisdiction, you can't exclude jurisdiction, exhaustion of domestic remedies. We're not talking about what happened to ND and NT 3 months after this particular expulsion. We're talking about this particular expulsion. And on that particular day, you know, you did expel them without any procedure and immediately. On evidence, you know, they said, yeah, the government could not hide behind the lack of identification when they were themselves responsible for it. And they found a violation of both the prohibition of collective expulsion and the right to an effective remedy. And then the Spanish state asked for a referral to the Grand Chamber. So it's not called an appeal, but it's basically like an appeal, but you have to start everything. So you have to you do submissions. The Grand Chamber doesn't take into account what happened before. So you've got to do submissions all over again. And then you have again, third-party interveners. And the Grand Chamber is, so a chamber decision is 5 judges. The Grand Chamber is 17 judges, including all of the presidents of the different sections of the court. There's 5 sections of the court. So those are the judges of the Grand Chamber. And I, on purpose, took a still where they're not very orderly because they like to present themselves in this perfect, beautiful order. Here they're sitting. But as you can see, they're absolutely all white, middle class. And that's how it looks like. And they were judging this situation where a group of Black men were being brutally and without rights taken off offense by, you know, white border officers. And again, we had third-party interveners, including the UNHCR and the Council of Europe's Commissioner for Human Rights, and they both applied to also be present at the hearing. So it's quite rare to have a hearing in front of the Grand Chamber. It's even more rare that third-party interveners would really insist on being present. So that's them. On the left-hand side, UNHCR, on the right-hand side, the Commissioner for Human Rights. I must say, Commissioner for Human Rights, Dunja Mijatovic, I'm a big fan. She's from Bosnia, she was a refugee herself, and she really gets those issues. And then we also had in writing Amnesty International and the Spanish Commission of Assistance to Refugees. And when we received the questions for the Grand Chamber hearing put in written writing by the judge rapporteur, we were really surprised because they were all about asylum and access to asylum in transit countries and access to asylum in the Spanish embassy in Morocco and access to asylum at the border crossing, which we really didn't understand because access to asylum as such is not a right in the convention, and the case was never about that. So also on top of the third-party interveners, 3 states intervened, and they all argued that there should be a lawless zone at the border, basically. And they all said it completely made sense in terms of migration management, and that's what should happen. Now, I've taken quotes from the hearing to kind of explain, I think, what happened at the hearing. So the Spanish state's lawyer, during the hearing, his opening to argue that there had been no violation of the prohibition of collective expulsions. That's him. That's what he said. Suppose you are at home with your couple and children, you are caring, supporting, and humanitarian. You would give entry to any person in danger or in need to your home, just if they knocked at the door and explained their reasons. Suddenly, you see 60 strong men coming, menacing to break your windows. And then your reaction is to close the windows and to secure shutters and blinds, refraining from the use of weapons and still keeping the door open to normal means. Are you preventing entry to your house, or are you expelling people? Who is being violent and unlawful? Who has not been willing to comply with reasonable requirements of entry, and who has not? So I remember I was at the hearing, and I remember hearing this and just finding it really, really hard to stay on my seat, because it was so clear that, so there were 600 men at that opportunity of another case to give his view on our case. So he just, it was another case, also borders, but not prohibition of collective expulsion. And he just did a concurring opinion where he just said what he thought about what the outcome should be in ND&NT. And one of the things that he said that stuck with me also is that although it was justified as an attempt to curb illegal immigration, human trafficking, or smuggling, the physical barriers reflect an ill-minded isolationist policy and represent, as a matter of fact, the prevailing malign political Weltanschauung in some corners of the world, which perceives migrants as a cultural and social threat that must be countered by whatever means necessary, and views all asylum claims as baseless fantasies on the part of people conniving to bring chaos to the Western world. And in fact, what the Grand Chamber came to these conclusions. So on jurisdiction, they still rejected Spain's argument that had been backed up by France, Italy, and Belgium, and said, even though there is a special nature as to migration control, it cannot justify territorial areas that are outside of the law. On the exhaustion of domestic remedies, they also said, nothing of what Spain has suggested, like applying for a visa, was one of their things. None of these can be considered like a remedy against the expulsion that happened on that day. On the evidence, also that, they took the Chamber's arguments and said, you caused this, so we need to. We can't say that they don't have conclusive evidence. We need to check what evidence they brought, and we find it good enough that we will take their version of events. And then they dismissed the 2 violations. And so basically for the prohibition of collective expulsions, they said it is an expulsion. So this argument that like, if you haven't legally entered, you can't be expelled, they dismissed that. They said, no, it's an expulsion. Like they were on the territory and they were brought away from the territory. It's an expulsion. Also, it is collective because their individual cases have not been examined, but it's not going to be in violation of the of Article 4, Protocol 4, because it's their fault. So they use this concept of the own culpable conduct. And the own culpable conduct is the conduct of persons who cross a land border in an unauthorized manner, deliberately taking advantage of their large numbers and using force in a way that creates a clearly disruptive situation, difficult to control and endangering public safety. And just coming back to that situation, this was the situation. So I think we can clearly say that public safety is hardly being endangered because like there's nobody around, just the guardian, like just the border officers, right? I mean, it's not like in the middle of a city where you have, I don't know, like kids playing next to it and like a market or something. And then, so with this own culpable conduct thing, like one of the things that the court said they had to look for was whether there had been a genuine and effective access to means of legal entry. So they said, if you've had a genuine and effective access to means of legal entry, like why would you like 600 of you go and attack the border? So in checking whether this existed, they acknowledged that, there was no border office that could look at asylum applications. So they made it all about asylum. And the question was like, did NDNNT have any other means to like put an asylum application, even though we never had said that they wanted to put an asylum application in the first place, but never mind. And they said, yeah, it's true. Like the Spanish authorities did set up an office at the border for registering asylum claims, but this was shortly after the events. So, okay. However, even before the setting up of that border asylum registration office, in that year, there had been 6 applications at the border crossing point. And on the basis of those 6 applications, and actually it's not true, we've made a video with an organization called Forensic Architecture to show that the evidence that it was a misunderstanding and a misrepresentation from the Spanish lawyer, that there had been 6 applications at the border crossing. There haven't. And there's documents from the Ministry of Interior, Spanish Ministry of Interior actually proving that. So we kind of published these and really showed that this was like not true, factually not true. However, even if it had been, it's kind of difficult. I find it difficult to justify on the basis of 6 applications when you have thousands of migrants somewhere, that you've had like 6 applications within 8 months to then conclude that there's genuine effective access. Because obviously, even if there had been these 6 applications, those would be really exceptions. And then, so if you've had genuine effective access, there's still a door out, which would be, do you have cogent reasons why you didn't use them? And one of the cogent reasons would have been, in their case, racial profiling, because it was clear from all of the evidence, including like a really long investigative article, that Black migrants could not access the Spanish border crossing because they first need to go through the Moroccan border crossing, but they can't even get into the city because they get beaten up. So they lived at the time in the forests and couldn't even approach the city center, let alone like the Moroccan border crossing, let alone the Spanish border crossing where the asylum office was. And this had been said and explained at length in writing and at the hearing by UNHCR, which is an organization that was present at that border and throughout, from 2014 and throughout, by the Commissioner for Human Rights and by a number of other organizations, including UN bodies. But the court said, well, we're not really convinced, like we'll go with the Spanish state. And also, it's not Spain's fault if there's racial profiling on the Moroccan side, so it cannot constitute a cogent reason. So still, it's NDs and NT's own fault, even if they've been subjected to racial profiling. So that was a bit of a shock as a decision, I must say, because it kind of says that it's your fault if you're racially profiled. And it also says that you can strip people of their rights because they've been racially profiled. It's a bit, yeah. But another point was also that the court never looked at, so if we go back to this test, deliberate taking advantage of large numbers in order to endanger public safety, the court never really looked at, and also the use of force, they never really looked at that. They never really asked themselves if NDNNT had any intention. And this was picked up after the decision. The same judge, Pinto de Albuquerque, took another case to give again his view on NDNNT. And he says a lot of things, but one of them that again really stuck with me was that the most appalling aspect of the line of reasoning of the court was what he called a reductio ad Hitlerium, by which there is guilt by association, whereby all Africans climbing the border fence share the same intention and are in the same personal situation, because NDNNT specific intentions to disrupt and endanger public safety were never established, and no evidence was ever put forward regarding any concrete violent acts committed by them on that day. So conclusions, so that is still the jurisprudence of the court on pushbacks. It's still the highest. There's been no other case looking at that since then at the Grand Chamber. We immediately said that it was a carte blanche to this systemic practice. We've been criticized by a lot of academics for having said that, but actually it really held true. And in fact, a few months after the decision, the president of the court went on tour to Greece and went to speak to the Greek parliament. So Greece is the other place where a lot of pushbacks happen, and said, this decision would apply at your borders too. Which was clearly an invitation to continue pushbacks. And in terms of our strategies now, we've had to give up on the idea of proving that migrants who are not considered refugees have rights too in front of Strasbourg, in front of the European Court of Human Rights, because obviously the current court, it's a very conservative court, I must say. It's very different from the court that did this other judgment, this Italian judgment of 2012. The judges have changed, and the states have put forward judges that are really conservative and not human rights focused. They used to put experts of human rights as candidates for that judgeship, and they don't do that anymore. They put prosecutors and tax lawyers, and it really shows in the way that the cases are being dealt with. And so we've given up on that idea, and now the cases that we do support are cases of people who do have vulnerabilities, like refugees or children, unfortunately. However, we have not given up on that idea in front of UN committees. So there is an individual communication proceeding possible in front of UN committees, and we're really trying to push to get an acknowledgement that it is about legal subjectivity. It goes beyond being a refugee or an economic migrant, but it is about being acknowledged as a person who holds rights. And I will just stop talking soon, but I will finally say that when we got that judgment, and even though it was a shock, I could only remember, there's this book written by a woman called Marie-Bénédicte Dembourg, which is titled When Humans Become Migrants, the jurisprudence of the European Court of Human Rights on migration issues. And her premise is that the European Convention of Human Rights system was always racist, and that from the start, the states actively managed to exclude their colonies. So colonial subjects were always excluded. And in fact, France didn't ratify the protocol that allowed for judgments until 1972, until they had lost all of their colonies. And that the progressive jurisprudence that we had seen was really exceptional. So either it was based on cases that didn't have migrants and racialized, and applicants that were racialized, or the situation was so atrocious that the court had no choice but to acknowledge a violation. And so, after being shocked by this decision, my second thought was, yeah, well, like, we've proven the racist bias of the court, basically, which can be seen as a success, I guess, but it's still really sad. Yeah.
Thank you so much, HANAA, for the very informative session. And it is actually very concerning and, as you said, very disappointing and a very depressing topic, as to say, especially when the arbitrary expulsion was happening without the individual procedure being provided to the migrant, to each migrant cases. And indeed, the judgment, uncertain points made by the Grand Chamber were shocking, because they could be perceived as a carte blanche for violent playbacks everywhere in other states, I'm sure. So, but as you said, we are hopeful, and it is certainly the case in a lot of other countries, not only in Europe. We could also see certain things happening in a similar manner in our country, India. But your litigation has an impact beyond an individual case, I'm sure. And it is a very painstaking research and work that you've done. I would like to request the participants to write your questions or ask the questions directly. Write your questions on chat, if at all. We'd be taking questions now. Or if somebody wants to speak, they could raise hand. There's an option of raising hand, and they could speak directly and ask questions from HANAA. So I see Fazl's question here, HANAA, which says mechanical expulsion of the migrants and refugees is violation of international human rights instruments. Did the court look into this aspect while deciding the case?
Yeah, I mean, this is the point, that like the prohibition of collective expulsions is part of the convention, of the European Convention of Human Rights. So in that way, it is introduced in what the court should be protecting. But they just made their own jurisprudence, kind of, introducing this new exception that is very difficult to grapple with, because it uses a lot of terms that remain completely undefined. So they've been quite heavily criticized, I must say, by academics and Spanish judges. So like there's an association of Spanish judges that called, this idea that Black migrants could have other access to any kind of protection at the border. They called that chimeric. They said, like, anyone who says this really has no idea, like knows nothing about this border. But beyond that, I mean, beyond the, I think that case puts the European Court of Human Rights at dissonance with the rest of international law on that point. But also beyond that, in terms of evidence, like I think it's really unsettling that the court just decided it could completely disregard statements from the UN Special Rapporteur on the human rights of migrants, and the UN High Commissioner on Human Rights, and UNHCR. I mean, any UN body, really any UN body who's looked at the situation made statements about this, like also the Committee for the Rights of Migrant Workers. Like, I mean, we had such an amount of UN declarations that it came even more as a shock. That the court just really, in one sentence, they just say, they say, yeah, we've seen this from the UN, but we just don't find it convincing. And we'll just take this like one statement made by the Spanish lawyer, literally like a statement he made during the hearing, which is not only not backed up by the evidence he presented, but actually contradicted by the evidence he presented. We'll just take the statement he made, take it at face value, disregard all the evidence, and go for it. And I think it is because they really disliked the fact, I mean, really thinking about it, I think what they really hated, I mean, aside from the racial bias, which surely exists, I mean, the decision is full of the term violent and attack, when like these guys were not violent, they were beaten up, like, okay, like they went in numbers, because that's the only way you can get through to climb this fence. But they were not being violent as such. I mean, if you define violence as climbing a fence, it's it's a big step, I think. But I think what the court really disliked was that there was no tale of misery. They just came and claimed their right. They didn't try to convince that like their situation was so bad that like, please protect us. It was just, you know, like, this is your jurisprudence, this is the situation, there's a violation, please find it. And yeah, it just, I mean, you know, we know this also with poor people or with women or with anyone who's kind of minored, that like, unless you have this tale of misery when you're facing like those institutions of power, they won't just give you a right, you know, like they would do with like a big company or something. So yeah, I think, yeah, there is a problem with that jurisprudence and international human rights law for sure.
I have a follow-up question. What is the role of the European neighborhood policy in this Moroccan migration issue, followed by the agreement they had with the Spanish-Moroccan readmission agreement? How does these agreements play a role in these kinds of cases?
That's a really good question, because like countries who do pushbacks always say, oh, we have a readmission agreement. I mean, first of all, they don't actually follow their readmission agreements, because the readmission agreements have a procedure. Like, they're supposed to register people, right? They're supposed to issue paperwork. They don't do that. So like, and there was evidence of that. Like, there was evidence, I think it was UNHCR who like pulled it up and said, okay, it's been used 6 times. So the fence has been up since 2005. The pushbacks have happened since 2005. So this is like 9 years of practice with this readmission agreement. And UNHCR said, listen, like, they've used it 8 times or something in those 9 years. And like, we have, you know, they acknowledged that they've like, I mean, the numbers that we had, I think in 2004, it was like something like 20,000 people being pushed back or something. I mean, it's like big numbers. I mean, it might be the same people, right? Because people stay at that border and try again and again and again. But like, it was because Spain would brag, like they would publish articles, be like, way, our border officers, like, you know, expelled 600 people today. So we took all these articles and sort of, it was like, yeah, tons of people. And it's still like today in Croatia, it's still tens of thousands of people being affected by pushbacks every year. So the readmission agreements have this personalized like side to them, even though it's not great, because it's just, you know, write the name down and write the country down and stuff like this. But also, so this is one thing, but also the readmission agreements cannot be above the European Convention of Human Rights, and this is really clear. And they cannot be above also EU law. So like, you can have all the readmission agreements that you want, you still have the obligations that, you know, to kind of, in particular, look at whether the expulsion would put someone in a situation that would expose them to, for example, destitution in the country where you expel them. So if they're a refugee, like, you need to make sure, under the jurisprudence of the European Court of Human Rights, you need to make sure that wherever it is you're expelling them, they will have access to a good asylum procedure, but also to means of survival. So this is one aspect. The other aspect would be also like, you need to identify unaccompanied minors and give them protection. So all of these things, like readmission agreements, cannot take away those obligations.
So while seeing that picture which you have shared of the Spain border and where the fence is, technically, when you look into the refugee definition, they have crossed the international border wherein they entered into the Spain border. So the principle of non-refoulement will apply on these people. And Spain would be bound, because it's one of the signatory, to give them asylum in the country. So it's in a clear violation of the principle of non-refoulement, if you can see that way.
I think that would have been the case had it not been for the fact that we specifically took people that didn't wish to apply for asylum and didn't have asylum claims. I mean, not one of them did, one of them didn't. Because we wanted to make the point that like, economic migrants have rights to, you know, anyone, like, you can't just push people as if they were like dogs and cats, right? Like, you've got to know, I mean, and also the point is, unless and until you identify everybody, you've got no idea whether you're actually committing refoulement or not. And UNHCR did say that. They said, yeah, it's linked, you know, you need to protect everyone under the prohibition of collective expulsions to make sure that you're actually complying with non-refoulement, because otherwise you don't know who you're pushing, you don't know where they're from, you know nothing. So I think, yeah, but that the court kind of didn't accept. In the judgment, they did say like, this is without damage to non-refoulement, and had they had a claim under, so the way that non-refoulement is implemented under the convention system is Article 3 and the prohibition of torture, cruel and degrading treatment. So they, you know, they said like, had they had a claim under Article 3, the position would be completely different. And in fact, it is the first case that really presents Article 4, like the prohibition of collective expulsion on its own. You know, previously they kind of always came together. But our point was that once you have once you have a claim under Article 3 and the prohibition of torture, inhuman and degrading treatment, you don't need the prohibition of collective expulsions. So if the prohibition of collective expulsions exists, it's precisely to deal with that step just before you know if someone's going to be refiled or not. You need to individually examine everyone's case. And that's, I think it's so clear that like, otherwise you can just get rid of that. You can just get rid of the prohibition of collective expulsions. If you're just saying, you know, yeah, you need to just look at whether they'll be tortured or, you know, treated in an inhuman or degrading way.
Thank you.
I hope, yeah, that answers.
Thank you so much.
Yes, it covers some part of it, but we can have a further, I'll email it to you, my concerns and queries relating to the same.
I mean, it's still to be seen. I have to say, there's been cases since then, not Grand Chamber, where as soon as Article 3 and non-refoulement is clearly involved, the situation is much clearer. Okay. You know, what is still unclear though, is what happens the day that a bunch of refugees, acknowledged refugees, go in hundreds and climb a fence. That's still not clear.
Yeah, so I was asking the question because in India, the government issued an order of expulsion of 40,000 Rohingya refugees to Myanmar. So it's a collective expulsion where they have not done individual study of each cases, how it will be, whether it will be safe or not. And they have just passed an order, which is being challenged in the Supreme Court of India and is pending before the Supreme Court. So we can take these arguments as well there, that there should not be any collective expulsion of the refugees from India.
Yeah, and I mean, don't know if this is the place, but if you're involved in the case.
I am involved in the case. Yeah.
Okay, because I don't know if you need this at all, but if you do, we've done quite a lot of research about like the prohibition of collective expulsions in terms of a principle of international law.
Yeah.
Yeah, so if like, I could just send you that if you need it.
Sure, I'll just write it to you so that you can send it the materials and which we can be used in the Supreme Court.
And just for the organizers, I'm happy for my contacts to be passed. Like, that's fine.
Okay, thank you.
Thank you, Fazal. Anjdeep raised her hand. She'd like to ask a question.
Hi, HANAA. So one issue that we're facing in India, which you also mentioned when you speak about Article 3 and you say that, you know, they're facing threat of persecution, but it's not in Spain, it is in Morocco. And it was dismissed because it was in Morocco, right? So in India as well, we recently had a Supreme Court judgment where the Chief Justice himself said that, you know, whatever is happening in Myanmar, whatever is happening in any country is not our concern, you know, which goes against like the entire protection regime, because they need protection because of what is happening in their country of origin. So since this already happened to you in the, I forgot what is the name of the lower chamber, were you planning to take it back to the, are there any arguments that you built to counter this entire thing of that it's not our concern what is happening in Morocco? If they're facing persecution in Morocco, it's not of our concern. Because this is a Supreme Court decision in India, it, you know, it haunts us.
No, I understand. I mean, so the viciousness, I would say, of the European Court of Human Rights argument is that it's not, but I think it's difficult to like even understand because their test is like so complicated. So they didn't even say whatever happens to Morocco, we don't care about in general. Because again, if they have like a claim under non-refoulement, so this would be Article 3 framework, so this prohibition of torture. We don't have, the convention doesn't have non-refoulement, and it doesn't have access to asylum. It has the prohibition of torture, inhuman and degrading treatment, and this is under this prohibition that all of the asylum regime is implemented by the European Court of Human Rights. And interestingly, the first case when this was done concerned the extradition of a German guy to the US. So this is one of the cases where I was talking about this, this book that talked about like whether it was progressive or not. She says no, because the whole, like even the whole framework of like even protecting refugees was only possible because of this German guy that was going to be extradited. And before this guy, there had been loads of applications by like racialized people that had all been dismissed. Anyway, just by the by. But yeah, so what the court is saying is it's not about non-refoulement. It's really about this, like, did you have a reason why you couldn't have gone to the border to claim asylum? So if they had gone to the border to claim asylum, like they wouldn't say, or whatever happens is none of our concern. But like what they did say is, well, if your reason is racial profiling on the Moroccan side, we don't care. So yeah, so it's, it's not, but maybe more broadly, like answering your question, and maybe another question by Aratrika Baumik, is that we've kind of given up on the European Court of Human Rights, maybe like you may want to give up on your Supreme Court. I mean, without, I know it's a tricky thing because like those are the binding decisions, so you kind of still need to work with them, but like knowing that you don't have allies, it's really a difficult task, I find. Like every time I have to write submissions, I just don't find the motivation, because I think, what's the point? Like, they're not listening, they don't care, they just try to find a way to dismiss my case, right? Like, it's really hard. But we have been using the UN more because on the side, because I think one thing that we can do is to just create jurisprudence at UN level to be able to then say, you're not in line with international law. And that's been our strategy. And I see that question about DD. So DD was our case because we were thinking, so we took a similar case. So that's the pushback that I actually saw when I went to Melilla, was the pushback of DD, who was a minor, who was pushed back the same way. It was also because in front of the UN, you have much more time than in front of the European Court of Human Rights. European Court of Human Rights, we have 6 months, now 4, which is really difficult when you're dealing with migrants. And UN, generally it's 1 year, 1.5 years. So we took his case to the UN, and this was actually quite helpful because we now see decisions on pushbacks of children at the level of the European Court of Human Rights, which refer to this DT decision. Because of course, I don't know how your judges are, but like within the European Court of Human Rights, they don't all agree, right? Like you'll have some progressive judges and you'll have some conservative judges, and it kind of depends of the making of whoever is considering your case. So we just want to give ammunitions to the progressive judges to be able to corner the conservative judges with international law, if that's at all possible. I don't know if that answers your question.
Thank you. Yes. Thank you.
Thank you so much. There's a question on the chat by Komal. Would the compensation of approximately rupees 10 crore by Italy be considered enough for the killing of Indian fishermen by Italian Marines? Would you like to take this question up? I think
I'm not sure I can, because I don't really know.
Yeah, it's absolutely fine. There's another question by Anshum Goswami. Can you also please talk about the political scenario of the country and how did that must have affected this case and such a judgment was passed?
Actually, that's a really good question. And unlike what you're expecting, it's the other way around. So I'll explain. In Spain, everyone, like the government, was 100% expecting to have a violation. And the thing is, so when the expulsion that we litigated happened, it was just a practice. 6 months later, the practice was grounded into law. And the whole left was saying this law is completely unconstitutional, it's against international law. All UN bodies, this is why we had so many statements by UN bodies, like all UN bodies, any potential human rights organization or institution, anyone they all had issued statements saying, what the hell, what is this law? It's against international law. What about non-refoulement? What about the prohibition of collective expulsions? Blah, 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 blah. So they were all like super clear. And this was when the government was conservative. And then the socialists took power. They wanted to change the law, but they were waiting for the backup of the European Court of Human Rights because it gave them much more legitimacy. So they said, okay, hang on, let's just wait for this judgment. But then what happened was that European politics played, whereby the German judge in particular, who has no idea about the real situation, but also doesn't really care. Like they just want to stop people from coming, right? Like just, you know, these like conservative judges took this super racist decision because they just didn't like this case. They didn't like these two young guys who were just like climbing fences and then saying, you should have processed me. When basically what they were saying is, I mean, you know, essentially in a nutshell, what we were saying is you should have processed them. You may have still reached the conclusion that you could expel them, but still you should have processed them. This is what we were saying, right? Because we were saying, yeah, they don't want to claim asylum. They may not have actually a claim, but still you should have processed them. Because in reality, had they processed them, they wouldn't have been able to expel them to Morocco. They would have had to transfer them to mainland Spain, and probably they would have never deported them anywhere, right? Just because of the technicalities of deporting people. Anyway, the judges didn't like this, so they took, you know, they found a non-violation, and then like there was a political crisis in Spain, because half the government was saying, we can't follow this decision. Like this decision is absurd. Like, you know, like what do we do with this now? And I think it's still sort of going on. So we then had to do a lot of advocacy saying, you know, what the European Court of Human Rights doesn't really matter because we have this UN decision. So like the expulsions are still in violation of international human rights law, and in particular, the Convention for the Rights of the Child. So, you know, you can still work with that. But I have to say that that is still law. Although it doesn't matter so much now, because what happened was that Spain gave a lot of money to Morocco so that Black migrants can't even get to northern Morocco anymore. So they can't even go to the fence.
Thank you so much.
And if anyone has tips about like how to deal with really hostile courts, I'll take them.
There's one last question with us, unless somebody else writes another question, raises hand. There's this question by Aratrika. The recent cases of ECtHR have been heavily criticized, as you mentioned, wherein they have failed to uphold principles of no collective expulsion and non. Do you think this is more treaty bodies such as UN Committee on the Rights of the Child for adjudicating of cases and for progressive judgments such as DD versus Spain, 2019?
Yeah, I think as I mentioned, so DD was our case too. And yes, it completely makes sense to focus. So the problem with the UN is that it's non-binding. So we want DD, Spain's saying we don't care, basically. But we can still use it for advocacy. Like Spain saying, yeah, good for you. This is not binding. We don't care. The European Court of Human Rights said we were right. So who cares? Which is not a really good argument, because actually, I think if DD had gone in front of the European Court of Human Rights, it could have been won, but we didn't have time. Could have been won because he's vulnerable, because he's a minor. So his situation is different from the two young, healthy Black adults that the court was facing when they had to judge on the ND and NT case. And finally, their reaction was, yeah, of course they didn't give us, like, of course they found against us. Like, you know, we've seen what happens at the border. Like, we know you're racist. Like, why is this a surprise to you? Which, you know, we were devastated and they were like, of course, but it doesn't matter. Like, we got our story across, you know, so that was nice. They were like, you know, what matters to us is that you take our case and you put like our story out there. But yeah, UN makes complete sense. And I think the UN is trying to be quite proactive because they're really scared of this court, actually. And in fact, even so, we have the EU, so we have this Council of Europe thing, and we have the EU, and the European Union's courts generally weren't seen as very progressive. But interestingly, like, because the European Court of Human Rights is being so conservative, like bordering fascist, the European Union Court is being super progressive. So we've had cases where the European Court of Human Rights has found no violation, like on crazy grounds, and then the same organization took the same case to the European Union Court, and, you know, so the European Court of Human Rights be like, no, this is not detention, like, you can just, you know, you can just illegally enter the next country, so it's not detention. Basically, this was the case. It was detention at the border. So it's Hungary. They detain people at the border, but they leave the door open. You can only get out. You can get out into Serbia illegally, but you can get out into Serbia. But if you do that, you leave your asylum application, like, that's it, your case is closed. And the European Court of Human Rights said, yeah, so it's not detention because you can leave. And the European Union Court said, of course it's detention. Like, if you, you know, if you make an asylum application conditional on the premise that you have to stay in this transit thing, like, of course it's detention. So we're having this situation now. And yeah, I don't know. Let's see what happens in the future.
Thank you so much, Hannah. I think that is it for now. There's no more questions, but we're taking inspiration from your work, and it was absolutely an enriching session. There's so much for us to think about, to learn, to interrogate, and to take responsibility for. And looking forward to using international judges and precedents. International laws and precedents. Thank you so much for your time and presentation. We will like to end here.
Thank you so much for your invitation and all of your questions and comments. Really inspiring. Thanks.
Thank you. Thank you so much.
Goodbye.
Bye, bye, bye.